Hey everyone, Eric Rodabois. We're gonna do a 5-minute video. So I had a client approach me and they invented a board game. And so he wants to know how to protect his invention and what are the different things he can do. So what's really cool is that this idea touches on all 4 parts of intellectual property that lawyers regularly handle. The first one are secrets, right? So once I come up with this invention, it's my secret, and obviously I'm gonna wanna try to protect it other legal ways, but let's say it's very preliminary, and I'm gonna be looking for investors, and I'm gonna be looking for potential partners, and I'm gonna be obviously, asking for money, and they're gonna say, okay, tell me about this invention, tell me about this board game. And so the first thing to protect your trade secrets is using contracts. Okay, what we normally do is we have what's called an NDA or a confidentiality agreement. NDA stands for non-disclosure agreement. And so what I'll do is I'll say, hey, potential investor, I've got this cool idea. I'd love to tell you more, but would you mind signing here? Now, in this world, we typically have 2 types of NDAs. We have the unilateral and the multilateral. So the unilateral is probably the one you're gonna want in this scenario, where you don't really have anything to tell me that I really care about, but I got lots of stuff to tell you that I want to keep secret. So I'm going to need you to sign this so that you don't go run and then steal my idea and take this to market before I can catch you. And so if you do, then I can sue you for breach of the NDA. Now, let's say that for whatever reason, the other guy says, well, I have things I want to share with you, then that might call for a multilateral NDA, where both sides are agreeing to keep the other people's secret. It's okay. So then the next step is we're probably going to want to consider the trademark and the branding, right? Because what the game is going to be called is going to be super important. Now, this might not be the next step in the logical progression, but eventually you're going to get around to protecting your brand, and that is going to be doing a trademark registration with the USPTO. Now, I've done videos about trademarks before. I will just say that there is such a thing as a common law trademark, which says that if you're the first person selling a particular good or service in a particular market, then you have a right superior to anybody else. And then people say, well, then why do I need to register? Well, I'm like, well, you're gonna register because it's gonna enhance your protection, it's gonna make your rights more powerful, and you're gonna be entitled to attorney's fees if you have to sue. Because otherwise we would be suing under the common law trademark, and as most of you know if you've watched my other videos, especially about the American rule, the common law does not allow for attorney's fees. So there are, however, state by state, we call them state trademark registrations. In this scenario, I wouldn't bother. You wouldn't want to do 50 state registrations or even 10 or even 5. Just do the federal one, it's nationwide. And then if you want to expand internationally, once you get the federal one, then you pick and choose the countries that you're going to expand to. So remember, that's trademarking for branding. The third, and everyone always asks this, can I patent my invention? And the answer is maybe. And patent law is its own very expensive, very complex area. It might be worth paying for a consultation with a patent lawyer to see if your idea is something that can be patented. And typically it's the way that the game works. So in this scenario, in my story, the guy basically has invented a new type of chess. So the way that the pieces move was invented like 2,000 years ago by the Egyptians. So I don't think anybody has a patent on how the chess pieces move. Again, this is a deeper dive that we might want to have a real consultation with a patent lawyer. Full disclosure, I am not a patent lawyer. I did not have the requisite math or science or engineering background from undergrad. So unless I go back to school, I will never be a patent lawyer. But what we probably can protect are the written instructions, how to play the game, and that we protect using a copyright. Now, the good news is that the copyright process, to a much greater extent than the trademark process, is pretty easy. Copyright is meant to be a pretty easy, and I always tell people, think about how much stuff is created every day, how many pictures, how many videos, how many songs, how many things are written. And so with all that content, when people want to protect it, they make a pretty easy, relatively inexpensive path to protecting your written content. In this case, you're gonna copyright the written instructions to your game. So what do I have so far? I've got an NDA to protect myself while I'm negotiating with investors. I've got a trademark to register my brand. I might have a patent, and I probably am gonna have a copyright for the instructions. And last but not least, we're probably gonna wanna set up an LLC or a corporation. We can talk about on a different day the pros and cons of each of those. But that'll definitely, if we're gonna treat this like a real business, then we need to pony up and take this step by step and have an actual LLC. Relatively easy to do. It also will make you look more legitimate if you're out there negotiating with investors and doing it through the name of a company instead of through your personal name. All right, everyone, obviously a lot to unpack here. Hopefully we can have some follow-up videos on some of these other topics. Thanks, everyone.